Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It's been just over a week since the Washington State University filed their answer and affirmative defenses in the federal lawsuit that is currently proceeding in the Western District of Washington, styled as Goncalves et al. Versus Washington State University. And in that answer and affirmative defenses, Washington State University, WSU, suggested that there might be third parties, people and or entities liable that might come to light during discovery in the case, which is a civil litigation tool and or an investigation, but did not clarify whether this is WSU's internal investigation led by their defense counsel, who is the Attorney General of the state of Washington, or if this is law enforcement's investigation that they're aware of that may be going on. It simply was not clarified. Now, the information in question appears at affirmative defense number 1 of the answer and affirmative defenses. And this is WSU's pleading. When you hear the term pleading, the answer and affirmative defenses is WSU's pleading. The complaint is the plaintiff's pleading. So if we look at affirmative defense number 1, what does it say? By way of further answer and first affirmative defense, defendant alleges that plaintiff's damages and or injuries, if any, were caused by the fault of a non-party, including but not limited to Brian Kohberger and or other individuals / entities that may become apparent through ongoing investigation and discovery. Defendant reserves the right to identify additional individuals / entities in this matter. So speaking hypothetically, we're going to give an opinion not based on any facts known right now, except for this language of the affirmative defense, speculation, throw out a rhetorical question, as we always do pursuant to the First Amendment to the United States Constitution. How would Washington State University possibly bring in a third-party defendant, a party that's not before the court right now? The only parties before the court right now are the 4 plaintiffs and the 1 defendant. So we're talking about future possibility based on the language of the first affirmative defense. Well, as we always say, when you're evaluating, looking at this case, discussing it with other citizens, other members of the public, always have the federal rules of civil procedure close by. It's not enough to just read any of the filings, because it is those federal rules of civil procedure that are promulgated. That means approved by the United States Supreme Court, SCOTUS, for use in federal courts, that govern the procedures and practices in civil cases like this one. If we turn to Fed Rule Civ Pro 14, third-party practice. A, when a defending party may bring in a third party. 1, so this is 14A1, Fed Rule Civ Pro. It says, timing of the summons and complaint. A defending party may, as third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. But the third-party plaintiff must, by motion, obtain the court's leave if it files the third-party complaint more than 14 days after serving its original answer. So we are right now at day 8 of when this answer was filed. Unless a third party is brought in the next few days and it goes past this 14-day deadline, then the defendants must obtain leave of court. And when you hear that term, leave of court, that means permission. So think that there's going to be, if that happens down the line past this 14-day window, a filing of some kind by defense asking the court for leave permission to bring in a third party defendant by way of summons and a pleading pursuant to Fed Rule Civ Pro 14A1. Now, the judge has already said that she is deferring the entry of the case management order, which would contain when the deadline, the absolute time that would expire in the case for bringing in third parties until after the pending motion for change of venue is entertained. If that motion for change of venue is denied, you're going to see a case management order coming out thereafter, which will have, amongst other things, deadlines for discovery and to bring in any third party. If that motion for change of venue is granted, then the case in the Western District will be deemed closed. The lawsuit will be transferred to somewhere in the Eastern District of Washington. That is the remedy. That means the relief. That's what the motion for change of venue asks for. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.